Hello, everyone. Thank you for joining us for today's event featuring Professor James Park speaking on his book, The Valuation Treadmill: How Securities Fraud Threatens the Integrity of Public Companies. My name is Srish Chatterjee, Professor of Finance and Business Economics at the Gabelli School and Gabelli Chair of Global Security Analysis. On behalf of the Gabelli School, a warm welcome. In the last several years, the Gabelli Center for Global Security Analysis and our wonderful co presenters, the Museum of American Finance and CFA Society New York, have sponsored more than 50 events that have drawn 8,000 plus attendees. We are tremendously proud of this dynamic collaboration, and a full archive of our video content will be shared in the thank you email you will receive. In just a moment, David Cowan, President and CEO of the Museum of American Finance, will give a full introduction of our speaker. Professor Park will deliver a presentation for about 40 minutes, at which point he will address questions submitted through the question field that is located below the video player. Please feel free to submit questions at any point during our event. We will be addressing as many of them as possible during the session. I also want to share with you that all attendees of today's event will be receiving digital copies of Professor Park's book with information coming to you following the event. And now I'm delighted to turn it over to my good friend, David Cowan.
Thanks, Suresh. So good to see you, all our Fordham CFA and museum friends. Welcome back to the fall season. It's my pleasure to introduce our speaker, who, upon graduation from Yale Law School, clerked for federal judges in New York's Southern District and Second Circuit. He became a watchdog as an assistant attorney general in the Investor Protection Bureau of the New York State's Attorney General's office. This role gave James a firsthand insight into the malfeasance by public companies. It also gave him important perspective on how public securities fraud has become a major concern to regulators. Now, since 2013, Professor Park teaches corporate law and securities regulation at the UCLA School of Law. He's a prolific writer with over 20 articles in peer-reviewed journals, and this is his second book. Now, while many have looked at this problem on a case-by-case basis or over a short period of time, say a decade, this is the first look at the compendium of the past 5 decades of public securities fraud. To demonstrate James's point, he has picked several high-profile companies with household names like Apple, Enron, and GE. One that is also featured is the fabled failed railroad company Penn Central, that was a conglomerate of not just railroads, but also terminals and hotels. And I just want to point out that we have an excellent collection in our archive of securities from that bankrupt company. Now, James focuses on corporate misstatements. This is not about things like Ponzi schemes or market manipulation. The museum covered those topics in 2010 in a titled exhibit Scandals. And when we were brainstorming for that exhibit, unfortunately, there were way too many choices and cases to pick from. Well, guess what? James also had plenty of cases to pick from. So let's hear about that now. It's my pleasure to turn it over to Professor James Park.
Thank you so much, Cerise and David, for having me today. When I worked at the New York Attorney General's office, I remember often walking by the Museum of American Finance, and it means a lot to me to be giving this talk to this audience. Thank you to all the family, friends, and students, both current and former, who are watching today. This book is for you. I wanted to send out a special thanks to my wife, Nellie, who read every word of the manuscript, and that's why there are no mistakes in the book. Thank you so much. And it was her birthday yesterday. Happy birthday, hon. Thank you for all of your love and support. I'd like to dedicate this talk to the memory of Judge Robert A. Katzman, who is the chief judge of the U.S. Court of Appeals for the Second Circuit. Without his support and mentorship, both when I clerked for him and many years afterwards, I would not have been a law professor and would not have had the opportunity to write this book. So this is a book about securities fraud in public companies. I started work as a practicing attorney about 20 years ago this month. And this is a time when securities fraud was the hot topic of the day. Enron had filed for bankruptcy in the winter of 2001. WorldCom followed in the summer of 2002, which helped prompt the passage of a law called the Sarbanes-Oxley Act of 2002, which basically requires every public corporation to invest substantial resources in preventing securities fraud. So when I had heard of this law as a young lawyer, I recognized the name Oxley. I actually went to high school in Dayton, Ohio, with a fellow named Ben Oxley. And Ben was always telling us about his uncle, who was in Congress. And his uncle was Mike Oxley, a US representative who represented Findlay, Ohio for many years, who was a co-sponsor of the bill. And so I've always had a sort of fondness for this law. I think of this as an Ohio law, and I'm an Ohioan. And I think it's a very common sense law, which says that if you're selling securities to the public, if you're traded publicly, you have to have a certain amount of integrity and transparency with respect to your financial reporting. In some ways, this book is a defense of Sarbanes-Oxley. It argues that securities fraud is not just a problem of bad individuals managers who decide to deceive investors. It's a problem that requires broader preventative measures. The book shows how securities fraud became a broad regulatory concern as methods of valuation began to change in the 1960s and 70s and throughout the 80s and 1990s. As investors focus more and more on evaluating projections of a company's future performance and valuing a stock, this has created structural pressure on companies to meet these projections, sometimes with deceptive mechanisms. And because it's a structural problem, I argue that there is a structural response that is appropriate. Another way of thinking of this book is it's a history of securities fraud regulation. As David mentioned, there are quite a few books that look at individual frauds. You know, Enron has the book Smartest Guys in the Room. Highly recommend that book for those of you who are just learning about securities fraud. Great new book on the Theranos fraud called Bad Blood. These books look at individual frauds, but what I wanted to do is I wanted to compare and contrast securities frauds over time. And my hope is that by doing so, we will get a better understanding of securities fraud and what drives it. I wrote the book in a way so that it would be of interest not only to law professors, it is an academic book and it makes an academic argument, but I think with the case studies, this book will be accessible not only to professors, but also attorneys, people working in finance. And I hope it's a good way of getting a broad overview of the problem of securities fraud in an interesting manner. So if you read the book, you'll see a lot of examples of different types of securities fraud involving public companies. In a basic sense, securities fraud occurs when a corporation deceives investors about its financial condition or prospects. But one of the lessons of the book, I think, is that there are many different types of securities fraud, many degrees of deceptiveness. And that's how I thought I would organize my presentation today. The worst frauds involving what I call making things up, making up revenue, making up a product. And these are the cases where we often see criminal cases brought, the most serious types of deceptions and securities fraud. An intermediate category involves specific misrepresentations, specific misstatements that may relate to, when was your revenue earned? What is the progress that you're making on a product? If you mislead investors using specific misrepresentations, that also is clearly a type of securities fraud. But often we see that with specific misrepresentations, there are often arguments on both sides as to whether or not the statement is misleading or not. These cases are often brought as civil cases rather than criminal cases, and they are often hotly disputed. A third and final category involves situations where a company does not issue a specific misrepresentation, but creates a generally misleading portrayal of its financial condition and prospects. And this is a type of situation where the law is much less clear. Can you commit fraud without issuing specific misrepresentations or misstatements? We'll talk about a few cases towards the end of this presentation where we see the SEC more aggressively bringing cases against generally deceptive practices. And to me, that's a very interesting development in the regulation of securities fraud. So to begin with my examples relating to making things up, one of the first major public company frauds happened during the 1970s. About 10 minutes from my office here in Westwood, California. I'm involved in an insurance company called Equity Funding. What did Equity Funding do? It basically made up fake insurance policies that were allegedly sold to people who did not exist. They had a special office in Beverly Hills where they had a staff that would put together these fake files, fake names, fake addresses, so that when the auditors came in, they would have something to show them to back up their sales. To make matters worse, they reinsured these insurance policies. Basically, they would sell off part of the risk of the insurance policy to reinsurers. And this created an obligation for Equity Funding to pass on the premiums it was receiving on the reinsured policies. The problem, of course, is those policies were fake. They did not exist, and there were no premiums that were coming in. And so this created a need to create even more fake insurance policies to generate even more revenue so that Equity Funding could meet its reinsurance obligations. So why did Equity Funding do this? This was a securities fraud. And this is a report from the bankruptcy trustee that I hope you can see on your screens. And it describes the motivation for making things up in this case. And the motivation is that Equity Funding wanted to report higher earnings, higher growth in revenue in order to boost its stock price. This created a vicious cycle, though, where to continue that pattern of growth, it had to make up more insurance policies. The CEO's staff begged him to stop. We're going to go to jail, they said. His response, as it says in the report, is that I can't report flat earnings. I can't report earnings that are not growing. Otherwise, the stock price is going to plummet. I mean, it's this pressure to maintain a company's valuation that begins to emerge around the late 60s and 1970s, accelerates in the 1980s and 1990s. This is what I mean when I refer to the valuation treadmill. As a public corporation, sometimes you are running hard just to stay in the same place, just to maintain your valuation. And this creates a structural incentive for public companies to commit securities fraud. You can make up revenue. You can also make up products. A recent example of this is the Theranos company. This is a company that claimed it had invented a machine, a portable machine, where you could take a single drop of blood and run multiple tests, multiple medical tests on that single drop of blood. This would revolutionize the medical industry. In fact, the machine did not work. It was not close to working. And the company basically created fake test results in its demonstrations with investors and potential partners who would distribute the machine in the retail market. Theranos raised hundreds of millions of dollars and based on the assumption the product was functional. It created projections of future revenue based upon a working product. The main question, the criminal securities fraud case that was brought against some of the executives, including CEO Elizabeth Holmes, was did she know? Did she know that the machine could not work, that it was completely not working? And her defense was, I believed it would eventually work. I really believed that this thing was going to work, and I knew there were problems, but I'm not an engineer. I don't know all the details of the technology. I believed that it would work. And that's often a common defense that we see in these types of cases that can be a formidable defense. Now, in the Holmes case, the jury rejected that argument. They found that she knew that the product had been made up. One of the interesting things is that one of the pieces of evidence they pointed to in some interviews after the verdict was reached were the fake projections, the projections that had absolutely no basis, that were sort of the grounds for a high valuation that investors gave the company. Just this week in the Southern District of New York, some of you may have heard that the founder of Nikola, which is a company that was trying to build a truck that runs on batteries, electricities. There's a criminal securities fraud case right now, this very week as we speak. And Nikola produced a video that claimed to show the truck driving on a road, to show that the truck worked and was functional. What they did not tell investors was that the reason it was moving is they took the truck to the top of a hill and they pushed it down. They pushed it down so that the momentum made the truck go forward. Another example of making things up. Doesn't happen that often, hopefully, but it does happen from time to time. And that's typically the types of cases that we see when we see a criminal securities fraud case. So it's not common for companies to make up revenue. It's more common, though, for them to issue misleading statements about when that revenue was earned. Companies often violate accounting rules in order to create a misleading portrayal of their financial results. And every public corporation represents that its financial statements were prepared in accordance with generally accepted accounting principles, often referred to as GAAP. And so if you're not complying with GAAP, you are deceiving investors. You are issuing misstated financial statements, and there's a particular misrepresentation there that we can point to if you are the SEC. In the late 1990s, Xerox, which invented the copy machine, an iconic American company, abruptly changed its accounting policies to accelerate billions of dollars to earlier periods. Revenue that would be earned in future periods was accelerated so that it was recognized earlier, in earlier periods. These cases, these accounting fraud cases, are often complicated because GAAP is very technical. It's very complicated and technical. There's often a lot of ambiguity as to whether or not a practice violates GAAP. And so what will often happen, and this is an argument that Xerox's managers made, is that we're not accounting experts. We're not auditors. And the auditor said it was okay for us to do this. Now, what they often don't disclose is that we really pressured the auditor to do this because we wanted to accelerate that revenue. But that can be a formidable defense in basically defeating the argument that there was fraudulent intent by the executives. So to win a case like this, you need to be able to tell a story, a motivation for why they accelerated the revenue. It's not just enough to violate GAAP, you have to show a motivation. And in Xerox's case, the motivation was they wanted to portray in the 1990s that they were able to keep up with the competition. A lot of foreign firms were introducing copiers around this time. Laser printers become a technology. We have a digital revolution, whereas there's less need for making copies, fundamentally threatening Xerox's business. This is a front page story from the Wall Street Journal that was published during the period of the deception. It doesn't get more public than the front page of the Wall Street Journal. And the CEO here is telling a story here about how Xerox is thriving and responding to the digital revolution. And if you look at the slide here, it notes that he points out Xerox has double-digit revenue growth. This is evidence to support his theory. That's why he accelerated the revenue. That's why Xerox accelerated the revenue, because if they had not done this, Xerox would have reported flat revenue and no growth. Xerox was an especially significant case in the history of the SEC because it was the first time the SEC imposed a major civil penalty on a corporation for securities fraud. In prior cases, they would often limit their penalty to individuals, individual corporate managers. And what they're saying by penalizing the corporation is that it's a structural problem. It's a problem where there's corporate incentives to commit securities fraud, and that's why we need to hold the corporation accountable. As David mentioned, another example, an iconic securities fraud, is the Penn Central Railroad fraud. Penn Central shockingly filed for bankruptcy in 1970, the nation's largest railroad that had just been formed in a merger that had happened a couple years before. Penn Central was a giant. It had been around for 100 years. It owned huge amounts of New York property, Grand Central Station, Penn Central Terminal. All of those were properties that the Penn Central had an ownership interest. They had interest in the New York Knicks, Madison Square Garden. All of this was from the profits they made on the railroads in their better days. Before the collapse of companies like Penn Central and Equity Funding, which happened around this time as well, securities fraud was not viewed as a threat for the largest public corporations, which were generating huge amounts of revenue and profits and faced little competition. In 1964, the SEC issues a report, a study of the capital markets, where they say securities fraud is mainly a problem for these smaller companies that don't have the money to invest in resources to issue correct financial reports. This really changes after cases like Penn Central. Penn Central is often viewed as a case study of corporate mismanagement. One of the last things that the board did before the bankruptcy filing was vote to increase manager salaries at the very last minute at the very last meeting before they actually turned to the crisis of bankruptcy that was threatening the company. But it was also a securities fraud. Penn Central used tactics that we actually see decades later in the Enron case. One of the things that it did was that it had all of these assets it had purchased in better years. And it would sell those assets to generate revenue and increase its profits. One example was they had an amusement park, the Six Flags amusement park, and they sold it to a partnership of investors. And they claimed that this had generated about $25 million in revenue. What they did not disclose was that the company, Penn Central, kept the risk of loss on the investment. And this violates generally accepted accounting principles because for there to be a true sale, you have to sell off the risk to the purchaser. It was not correct for Enron to claim that this was revenue that it could report. And so, sort of an interesting argument that happened around this particular transaction was that, Penn Central's defense was that this is not a material event. It's not a material transaction because it's $25 million. We're a multi-billion-dollar company. How would it change your perception of our financial condition? And a great accounting professor who taught in New York City at Baruch for many years, Abraham Brilloff, writes a great article where he says, look, the reason it's material is that without that $25 million, you would have reported a loss in a quarter where you promised to be profitable. And so the highlight here says that this is about meeting the projection. Going back to my theme about this emerging pressure to meet projections of financial performance, of future performance. $25 million may not be material in a world without projections. When we have projections, it is something that can mislead investors. After Penn Central fails, the SEC writes its first major document on a major public company securities fraud, a massive report, hundreds of pages long. And they advance a very interesting theory that I'll call a shareholder wealth maximization theory of securities fraud. It argued that the CEO was obsessed with doing everything he could to maximize the company's revenue and earnings, to hide the fact that the core railroad operations were deteriorating. And this is a shift. In the 50s and 60s, public company managers did not feel like they were compelled to maximize shareholder wealth. It's only more recently that we begin to see this pressure. And some scholars say, well, we can date shareholder wealth maximization to Milton Friedman's article in the New York Times Magazine in 1970, saying that we should maximize profits and do nothing else. We see it in these other contexts as well. In a broader sense, we see the SEC kind of thinking about this in the context of securities fraud. Even when a company doesn't make up a product completely, it can issue misleading statements about the progress that it's making on a particular product, especially during the 1980s when we have the boom in computer companies. You had a lot of companies there that were developing these promising products that could generate a lot of revenue in the future. Investors would take that into account in valuing the stock and award these companies high valuations. But if the company disappointed investors and the product was not as successful as they had believed, you could see the stock price fall, and sometimes securities fraud class actions were filed after a stock price decline. Before it became the world's most valuable company, Apple was a new public company that was trying to follow up on the success of its Apple II personal computer. Hopefully there are a few members of the audience who remember the Apple II, a really remarkable device that was widely sold. I was always envious of the people who had an Apple II. I never had an Apple II computer. So they were trying to follow this up with an office for the business market, a bigger market, and they called this computer the Lisa. And one of the features of the Lisa was that it had this high performance disk drive that it called the Twiggy. Again, some of you in the audience may not remember the days when we used disk drives. This is before cloud computing and massive hard drives. We had to carry around all our programs in these individual disks that we put into a disk drive. And it was very important for the disk drive to be fairly fast and high performing. And so the language here that Apple issued a number of statements that implied that the Twiggy worked and worked really, really well. They talk about its high performance as if they know it's going to be a high performance disk drive. They refer to years of extensive testing that was done on the disk drive, implying that the disk drive had passed all of these tests. In fact, the Twiggy, it sort of worked. So they didn't make up the fact that they had a disk drive. But it had all sorts of glitches, and a lot of customers returned them. And so Apple had to discontinue the disk drive, and Apple's stock price fell by like 25% on the day that this was revealed. And so the question in assessing whether Apple may have committed securities fraud is, did they know at the time they issued these statements that Twiggy had all of these problems, all of these glitches? And here are a few quotes from internal memos where just a few weeks before, the engineers are saying, all the problems are going to lead us to delay the introduction of the Lisa by many months. Steve Jobs says, "I have no faith in the team that is developing the Twiggy." Now he was kicked off the team that was developing the Lisa, so he may have had other reasons. He was criticizing the Lisa and the Twiggy, but this is evidence that while they're telling everyone this is a product that may work, internally they're really worried because they see that there are problems that have not been resolved. So this is one of the few securities fraud cases that actually goes to trial. So what's Apple's argument at trial? Well, their argument is that they didn't know the disk drive would fail. This is just how product development works, especially when you're innovating. You don't know until the very end whether it's going to work as well as you hope it will work. There's always a fire drill, right? And us lawyers can relate. Whenever you're filing a brief, no matter how long you've worked on it, there's always that last night where you're trying to fix everything and make sure it's absolutely perfect. And you see all of these problems you didn't see weeks before. And there's a fire drill at the end, and people are tired, cranky, exhausted. And that's why they're issuing memos about how, this thing is going to fail. Right. And so they have this line I love about, this reflects stress by overworked engineers under pressure. We didn't know that it was going to fail, that it would not succeed. The plaintiff's response in one of the briefs I uncovered is kind of a typical response, is that you're right, but you gave us no inkling that there would be problems. You issue statements that gave us no clue that there could be potential challenges. And as investors, we are entitled to the complete truth. The market relied upon these statements in valuing the company. And because they were false, we lost significant amounts on our investment. And this is the sort of argument that's made all the time in these types of cases. Hard to resolve at times. In this case, the jury sided with the investors and awarded $100 million to them. This verdict was overturned and the case settled for less than that, but this created shockwaves in the technology industry. And they exercised their lobbying clout and won in 1995 a law called the Private Securities Litigation Reform Act, which substantially limited private litigation. To go to a more recent example, if you think about Elon Musk's dispute with Twitter, he's essentially saying that Twitter committed securities fraud. He's arguing that the social media company misrepresented the percentage of its accounts that are fake. And this entitles him to exit the merger agreement. What do I think of this argument? Well, one problem is that it's very hard to prove that an estimate is objectively wrong. And in fact, Twitter has all sorts of disclosures noting these are estimates. These are not precise figures. There is no accepted way of estimating these fake accounts. And so that is likely going to be enough, I think, to shield Twitter on this argument, unless Musk finds a really big smoking gun, a red flag that indicates that they knew that these estimates were wildly, wildly off. To me, one of the ironies of this case is that Elon Musk has been one of the SEC's primary antagonists, has been very critical of the agency, maybe unfairly. Here he is appealing to the protection of the securities laws to protect him from Twitter, which allegedly deceived him. Okay. So as I noted earlier, one of the more interesting questions in securities fraud doctrine is whether a company can commit securities fraud without issuing specific misrepresentations. A nice example of this is a significant case the SEC brought against General Electric about a year or two ago. In this complaint, it did not point to any clear accounting misstatements or violations of GAAP, but instead pointed to the company's real earnings management, which I'm sure many of the business school audience members will be familiar with this idea, where you're not managing earnings by violating accounting rules, but you're making decisions in order to meet various metrics, what are normally legitimate business decisions to meet projections. As some of you know, GE is, or many of you know, GE is one of the nation's oldest public companies. It has a very special place in our business law, business history. It dates back to Thomas Edison's first company that sold light bulbs, known as a very safe and conservative investment. It's always paid its dividend until 15 years ago or so during the financial crisis. And during the 1990s, it also achieved and delivered very strong returns. In 2017, GE reveals massive losses in its power and healthcare businesses, and the stock price collapses. The confidence that GE could deliver smooth earnings was basically shattered. GE lost hundreds of market capitalization that it has not yet earned back. I saw the price fell again over the last couple of days in this new market turmoil. If you add up how much was lost by investors in General Electric, it's more than the losses suffered in both the Enron and WorldCom bankruptcies. So what did GE do? It's a kind of a technical argument here. And so it basically delayed reporting losses, reductions in cash flow through earnings management. Here's an example of what the SEC cites in its complaint as being a deceptive practice. So as with many businesses, in its power business, GE sells receivables, basically revenue it's going to collect in later years to generate cash today. Nothing illegal about that, nothing that violates generally accepted accounting principles. But what it does is that as it faces more pressure in its power business, it begins selling receivables that are further and further out. So normally they would be selling receivables for a year out. But now they're selling receivables for up to 5 years out. And so this is essentially cannibalizing future revenue. And the problem with this, it makes the company more risky in a sense, because if your performance continues to deteriorate, if it does not improve, then at some point you're going to have to acknowledge these losses, this lack of performance all at once. And so there's no disclosure about this particular move, even though it is technically legal. And one of the things I find fascinating about this 2020 case, which I think has not received the attention it deserves, is that for a long time it's been an open secret that GE manages its earnings. It's another front page story in the Wall Street Journal about how GE dampens fluctuations in its earnings. And part of the reason it does this is because that's what investors want, right? That's what the valuation treadmill wants, is predictable, smooth earnings, so I can more confidently project those earnings out into the future and basically have confidence that this is a stock price that has some stability. So to me, the fact that the SEC brought this case, they penalized GE $200 million, is an interesting signal about what the SEC thinks now about real earnings management. Another interesting example is Under Armour, the sports apparel company. Another recent case brought about a year or so ago. At the end of the quarter, if it wasn't generating enough revenue to meet a projection of 20% revenue growth, it would call up its customers who had ordered product for the future and ask them to accept it immediately. They might call up the baseball team, the UCLA baseball team, and say, we know your season doesn't start until the spring. Could you accept the uniforms in the winter? And by doing that, they could recognize more revenue to meet this 20% projection. So these are often referred to as pull forwards, and they don't violate GAAP. They don't violate generally accepted accounting principle. And if you look at the footnote in the SEC's complaint here, the SEC specifically says we're not alleging the sales violated GAAP in any way. But they can be misleading because they're creating the impression that Under Armour is achieving 20% revenue growth through its ordinary business practices. So one of the interesting things about the Under Armour case is that it shows how the valuation treadmill is still pressuring companies. It's not enough for Under Armour to report 10% revenue growth or 15% revenue growth. It has to be 20%, or else the stock price is going to fail. For the lawyers out there, one of the interesting sort of legal issues about this SEC case is that if you've ever done research involving private litigation that challenges pull forwards as violating securities fraud laws, courts often dismiss cases like this. They dismiss cases like the case the SEC brought against Under Armour. And so we begin seeing a very interesting divergence between what the SEC believes is securities fraud and what the courts have often found is or is not securities fraud. So we look into the future, we begin to see the problem of securities fraud is increasingly playing out in the context of disclosures relating to ESG risk. A few months ago, the SEC files a case against a Brazilian company with various securities trading on the New York Stock Exchange. One of its dams collapsed, very tragically creating huge amounts of environmental damages, killing 300 people. And as a result, the stock price fell significantly by about 20%. Now, one view of these cases is that now everything is securities fraud. If you read the Bloomberg Law columnist Matt Levine, this is one of his running jokes when he talks about securities fraud cases, and basically saying whenever something bad happens to a public company, they get sued, and investors claim that they were defrauded. In Vail's case, I think that that criticism may not be quite fair. The SEC uncovers a lot of evidence that Vail had internal estimates about the risk of the dam collapsing, and there was evidence that this was an unacceptably high risk of collapse. In its sustainability reports and other ESG disclosures, Vail is saying that our dams are safe, right? They're affirmatively representing the dams are safe without revealing the internal information of the risk of ESG failure here. And so I think we're going to see a lot more of these cases as there's more pressure on public corporations to issue ESG disclosure. And as we know, the SEC considering rules to mandate climate change disclosure. And that means there are going to be more statements out there that could be the basis for a securities fraud lawsuit. These disclosures will also create expectations that public company managers are going to be calculating ESG risk. And so there's a greater chance that there'll be a divergence between internal risk assessments and external risk assessments that could be the basis for a securities fraud claim. So I hope you've enjoyed this brief history of securities fraud regulation. Believe it or not, I didn't discuss all of the cases in the book. And just one last thought I thought I would leave you with is that as I was writing this book, I realized this is not just a history of securities fraud. This is a history of the public company, the public corporation, how it's changed over time. It goes from a situation where corporate managers are not pressured that much to deliver results to one where arguably this is a pressure that virtually all public companies face. And so to me, the issue of securities fraud regulation is a fundamental part of public company regulation that is developing and evolving in very interesting ways even today. Thank you very much.
Thanks on behalf of all of us. That was very interesting. We're sincerely appreciative. We do have some questions, and now is the time that Suresh and I encourage the audience to start submitting their questions. You mentioned Abraham Brilloff, and a dozen years or so ago, the museum had him twice before he passed away. You know, this was after the 2008-2009 crisis. I remember him lamenting very loudly, "Where were the auditors?" he was saying. And
Yes.
but so my question is, though, back on that period, why do you think there were not more prosecutions out of the 2008-2009 timeframe?
Thank you, David. That's a very important question, and I have a chapter in the book that gives my thoughts on why that was not the case. This has been a very hot issue, and it's still a controversial issue even today. As many of you know, Judge Jed Rakoff, a legendary Southern District of New York judge, wrote a very important piece in the New York Times Magazine about why there were not prosecutions after the 2008-2009 financial crisis, and very rightly questioning prosecutors. Were they afraid? Were they afraid of taking risk? And I think that's certainly one theory of that. In terms of securities fraud, I think the best argument for why these cases were not really brought was that there was an argument that the bank executives could make that they were just as surprised or almost as surprised about the extent of the financial crisis and how bad it got. Now, I think that argument doesn't quite work if you're thinking about particular company losses on subprime mortgages, but if you may recall, 2008, 2009, a wider range of assets were threatened, and a lot of these companies got to the point where they're essentially insolvent on paper. So could they have predicted that the extent of the crisis? And I think there's an argument that they were at least just almost as surprised as investors. And one of the key requirements in a securities fraud case is that there has to be a divergence between what the managers know internally and what investors know externally. And to me, I think that for a bulk of the losses, maybe not all of them, the executives had a defense like this that I think might have been difficult to overcome in a criminal context.
Thank you very much. I also have several questions on your talk and on the book, but first, let me thank you and congratulate you for writing this book on a topic that is generally, presumed to be very dry. Perhaps it is, but in your book you have excellent stories about these six companies, exactly what happened in Xerox or Apple or Enron, and so on. You also mentioned in your talk some extremely important concepts. First thing that you said is that this is a structural problem, and in the book, in the chapter on Enron, let me take an example of what I would think as a structural problem, sort of very interesting, puzzling problem, and that is that somehow the market was very irrational in valuing the stock and priced it at a level where perhaps management was then pushed to justify that price with inflated earnings. I believe it came to be known as the agency cost of equity. How do you solve those kinds of problems? And this is related to disclosure, except that now the company and the management has to disclose to the investor the truth about the company, which might mean a severe drop in the share price, which might impact their own stock options and things like that. So let me stop there, and I will follow up.
Thank you, Sri. So your question reminds me of an article by Michael Jensen on the agency costs of overvalued equity that he wrote around this time, that raises sort of a similar issue where the sort of irrational exuberance around the Enron, around that time, that was the first internet bubble, where there's pressure from all these companies that are receiving high valuations with very few earnings. And that's something we may have seen more recently with the second technology bubble, quite frankly. And that element, I think, of sort of what we might refer to as investor irrationality is very difficult for securities regulation to address when investors don't care about past financial results, and they're willing to pay pretty much anything for a stock. The SEC finds it very, very hard, I think, to address some of the pressures on public company managers. I offer a few suggestions in the book about projections and disclosure relating to projections. In the current system, there's no mandate that companies issue corporate official projections. If they did so, could this at times check irrational exuberance? If I'm issuing more conservative projections as a corporation and giving the basis for those projections, could that provide some check on some of the market exuberance? I don't know if it will. I'm not completely sure that it will. I don't know if it's a solvable problem. And it is certainly one that if we see more securities frauds in the future, then I wonder if that could be the cause.
We have a question from the audience, and I'll tack on a little something at the end of it. It's from Deborah. She thanks you, of course, for a very informative webinar. She wants to know if you think more strict audit procedures should be required, number one. Should the public pressure the government for more severe penalties, number two? And then I'm curious, seeing at least the cases you showed us today, do you feel the punishments fit the crime in the cases of, in some corporations, $100 million is not that much at the end of the day.
Sure.
So repeat those, but there's sort of three parts to that one.
All wonderful questions. Certainly there's always room for reform of auditors, and it's not something I emphasize as much in my book, but it is a very big concern. Where were the auditors when Xerox misstated its financial statements? Why did they give in to the pressure? So I think always, looking at auditors, looking at their incentives and looking at the rules governing them, I think is always helpful. But I'm hopeful, I'm optimistic in some ways that Sarbanes-Oxley seems to have helped in some sense in terms of giving auditors some more status in the process, and we haven't seen quite as many big financial statement frauds after Sarbanes-Oxley. So that may be some evidence that the law is working. Should we be pressuring the government for greater penalties? I think absolutely that's appropriate for the public to do. Does the government have to listen? I think that the government's also concerned about due process, about the rule of law. Those are important things to consider as well. And so it is hard for regulators to balance this, especially in the criminal process. Did the punishments fit the crime? And David, I think you're referring to the issue that corporations now see these penalties almost as a cost of doing business. We can just pay $200 million, and it's not. It doesn't really do very much. Professor Coffey at Columbia has an important new book continuing to criticize the practice of simply penalizing the corporation and letting individual managers off the hook. And I think it's a valid criticism. On the other hand, the government is restrained by due process, rule of law concerns, and it's tough to build cases against individuals. It's very, very hard to do that, and so I don't think I would advocate sacrificing those individual rights in pursuit of greater penalties.
You mentioned in your book, again, going back to the book and the examples you gave are all companies from this country. Uh, what about companies elsewhere? I mean, we obviously have a large global marketplace, and what's the situation outside of the realm of SEC and regulations that might apply to only companies here?
It's a great question. Other companies in other countries that they don't face as much valuation pressure. You don't really have quarterly reporting as the norm in Europe or Asia. That's my understanding for most public corporations. You have a greater concern and focus on stakeholders in Europe and even in Asia, and so that may sort of lessen some of the pressure to issue misleading financial results. On the other hand, you do see major, securities frauds from time to time, accounting frauds for overseas companies. And think of if you think about ESG fraud, Volkswagen, for example, had the scandal a few years ago about rigging its cars to cheat on environmental tests, and the SEC actually said that not only violates EPA rules, you didn't disclose this illegal conduct when you sold bonds overseas. And I think that case is still pending and being litigated. So, and the Vail case earlier, that's another case. It's a Brazilian company listed on the New York Stock Exchange and is being sued by the SEC for securities fraud. But I do think it is different in other jurisdictions where you don't have the same pressure that we see in the United States.
Michelle has a multi-part question that I'm going to add on to as well. She wants to know if you anticipate more SEC litigation regarding ESG disclosure, number one. Two, what area concerns you most? And so I'll go sort of 2A, is crypto an area that concerns you?
Really great questions. Yes, absolutely. I see the SEC being active in this space because when you mandate disclosure, disclosure needs to be backed up by enforcement. And I think that you're going to see more SEC cases. I think you'll see more private litigation as well as you see more ESG disclosures and plaintiffs' attorneys are always very creative in coming up with new theories, and I think those will be tested. So I think this is going to be a very interesting area of law, and that's one of the future issues and concerns that I'm thinking about a lot. And crypto is fascinating, and I think that it's already generating investor litigation, where investors in crypto are saying that I lost money on this token, and this was a security, right? And that's kind of interesting because when they bought the crypto, they may not have cared whether or not it was a security, but when they lose money, they want to argue it was a security because if it was a security and there was no registration, you get rescission, you get your money back from the company and your losses. And the other thought I would have on crypto is that if you think about the public company space, right? One of the criticisms of Sarbanes-Oxley and securities fraud litigation is that it overburdens public companies and it creates incentives for them to stay private. But the benefit of those regulations is that this market has integrity. We can rely upon valuations in this market to some extent. And I think the SEC has done a pretty good job of sort of kind of distinguishing crypto and saying this is something else, right? And it's not within this. It's either a commodity or it's a security, and you have to register it with us. And if it's to the extent if it's just something else, it's not really a regulated security, then buyer beware, right? You can't trust those markets, but you can trust public markets. And I think the collapse in crypto is unlikely to really sort of bleed over into the public markets because investors understand these are different types of things. But there's going to be a lot of interesting enforcement cases. And I think the SEC is going to get moving. I think they need to get moving. to reestablish a bit of order in what is sort of the Wild West of a lot of these tokens are probably securities, and they need to bring cases to establish that.
Do we have time, David, for?
Sure. Why don't you have one last question, Shirish, and then we'll close.
All right, thank you. This is a more general question I have, not just about SEC, but about regulation in general. Can we expect regulation to solve entirely these problems, or even 90% of the problems? We have had no shortage of regulations. We had Sarbanes-Oxley, then 2008, 2009, we had Dodd-Frank. So is it your feeling that we have to live with some of it, and that's the price we pay for having the kind of free market system that we have?
I would agree with that. I think that we need well thought out regulations, and we need to be careful about over regulating at the same time. And I do think that Sarbanes-Oxley is fairly sound and mostly accepted. There have been adjustments that the SEC has made to exempt smaller companies and newly emerging companies. That's something the SEC should always be aware of, because the bulk of regulation has to be through private ordering. And it's really the job of investors to look for frauds and look for suspicious companies and call them out. But they're not always able to find the more subtle frauds, and we're always surprised. We're always surprised, and that's why I think we need laws like Sarbanes-Oxley.
I have to say, being on this valuation treadmill the past hour, it went really quickly. It was thoroughly enjoyable. On behalf of Fordham and Shirish and the museum, myself, the CFA Society of New York, thank you so much. It was great. To our audience, join us again next Tuesday, same time, when we'll hear from Professor Bruce Usher of Columbia on investing in the era of climate change. Thanks, everyone. Great to be back again.
Thank you.
Thank you.